My name is Taso Pardalis from Pardalis and Ovica, and this is our weekly installation of Facebook Live Fridays. Today's topic is leases, commercial contracts, and force majeure provisions. We are literally and figuratively at the center of a financial crisis for businesses and both commercial landlords and tenants, as well as those in contracts of any sort. Businesses have been closed for weeks now, bringing cash flow velocity to zero. What should commercial landlords do, and what should tenants do during these most trying times? The first thing that everyone should do, of course, is take a look at their lease. Before taking any action, everyone has to read that lease carefully. There's a few very relevant provisions in every lease concerning the payment of rent and whether there is a force majeure clause. So we'll start with the rent clause. And in commercial leases, including and especially in triple net leases, there's typically provisions that provide that the payment of rent is absolute and without any set-offs, reductions, or deductions. That is a provision that you cannot avoid. However, the payment of rent provision may be subject to other provisions of the lease, including force majeure clauses. The force majeure clause is also known as the act of God clause or a superior force clause, and it typically lists events beyond the control of the parties to the contract or the lease. Events like war, civil unrest, labor strikes, natural disasters, and national emergencies. Some force majeure clauses in some contracts and leases even include disease and pandemics. The force majeure, the act of God, the force superior, is defined as an event that either suspends or excuses the performance of a party's obligations under the contract. As far as terms relative to a shutdown due to a disease, an infection, a pandemic, or quarantine, or a governmental act or prohibition, they very much so need to be specifically mentioned in the force majeure provision, as most leases are enforced according to the plain meaning of the terms. So you must specifically have language in this crisis referring to disease, pandemic, government prohibition, or shutdown for you to be able to use your force majeure provision to negotiate. Some leases contain force majeure clauses that expressly exclude the tenant's performance of monetary obligation, like payment of rent and additional rent. It may say that, yes, you can execute force majeure, but not as to payment of rent, meaning that even during a covered event, the tenant nonetheless must continue to pay rent and additional rent. Others excuse a tenant's performance of only non-monetary obligations and only during the time the event occurred. Parallel to this, we have something to look at along the lines of an argument of impossibility of performance. In addition to the terms of the lease, people need to be aware of excuses that may be invoked to excuse a tenant's performance. Impossibility of performance. Courts have held that impossibility of performance excuses a party's performance only when the destruction of the subject matter of the contract makes performance impossible. The impossibility must be caused by an unanticipated event that could not have been foreseen or guarded against in the contract. And specifically, for those of you that are thinking about impossibility arguments, courts have held that, especially in New York, that impossibility of performance because of a financial hardship does not excuse performance of contract. So you cannot argue that because of financial hardship, you have an impossibility of performance. What are we seeing now? What types of creative solutions are we offering? Are we getting into with clients and landlords at the moment? Look, right now, relying on courts to resolve lease disputes, it's not there. It's not a viable option. There are restrictions on judicial proceedings. Currently, there's a 90-day moratorium on commercial evictions in New York State, which extends through June 20th, 2020. And while commercial tenants are still legally and contractually obligated to pay, landlords are barred from commencing eviction proceedings or taking any legal action to execute warrants of eviction against tenants. Landlords, however, can still issue default notices, and they can still issue notices of termination of leases. What does that mean for tenants? Tenants, if necessary, can still go to court and file emergency applications for what we call Yellowstone injunctions or injunctive relief to freeze the termination of their commercial leases. So while landlords cannot evict you at the moment, they can say, hey, you have to pay me. And because you didn't pay me, I've now canceled your lease. And a tenant can then still run to court and file an emergency application. The court will accept those at the moment. Some courts, they're open in limited parts. They will accept emergency relief to freeze the termination until things are back to normal. But guys, with all of that, it's in everyone's best interest to be reasonable and flexible in negotiating in these times. So what we're seeing is, on the landlord side, if the lease term has many, many years to run, and prior to this situation and this current crisis, the tenant had been a good tenant and current on all its payments and its obligations, we're recommending and we're speaking with them and saying, look, there's value possibly in preserving this long-term relationship by making some short-term compromises, assuming that everything goes back to normal when the stay-in-place orders are lifted. This process usually begins with the tenant seeking some sort of concession. We're seeing a lot of people requesting lower rent. We're seeing a lot of people requesting deferment of rent until things go back to normal. But we're not just seeing negotiation of rent. We're actually seeing negotiation of other things like CAM, which is common area maintenance charges, or the payment of real estate taxes and insurance charges, and the timeline for those. And tenants are asking landlords to agree to defer the payment of rent and additional rent for some short period of time, with the understanding that that deferred amount is going to be repaid over an extended period of time and added into the monthly payments once things get back to normal. Instead of a rent reduction or an abatement, a landlord may agree to offer a deferment in payment of rent, as long as that deferment gets paid back later in equal monthly installments, okay? As far as the commercial landlords and tenants, we've been talking about relief a lot, and a lot of people have been asking. Both sides may be entitled to relief, including loans and grants, and even payroll protection under the recently enacted Coronavirus Aid, Relief, and Economic Security Act, the CARES Act, which is President Trump's $2.2 trillion stimulus package designed to mitigate the financial impact of COVID-19. So what I would tell you on both sides is be as creative as you can. If you think you're going to be okay financially with this, it's in everyone's best interest to compromise until we can get back to normal. And thank you guys for tuning in. I'll keep it short and get to questions. So Joe, if I am a tenant and landlord agrees to give me a break on the next few months of rent, do you recommend that something be put in writing? Because my lease says any changes have to be in writing, and it has these crazy notice provisions. Okay, so the recommendation is, of course, it has to be in writing if you come to an agreement with your landlord. It shouldn't just be like, yeah, don't worry, I'm flexible, see you in 30 or 60 days. What we've been recommending to both sides is that no matter what people are talking about, a lot of people are saying, oh, I want 3 months. So enter into a temporary deferment or abatement agreement that lasts 30 days and will be revisited by the parties every 30 days and re-executed. It doesn't have to be complex. It can be a one-pager. But we're recommending that all parties do this on a 30-day basis. That way, there's no misunderstandings about what 3 months or 6 months means if things open back up early and whatnot, okay? Rich, can you talk about a good guy clause and how that might come into play in the current situation? Many leases have what we call good guy clauses or limited guarantees, which say that so long as a tenant is not in default or behind on any of his payments or his or her payments, that tenant can execute what is called a good guy clause or a limited guarantee, providing the landlord with a certain amount of notice. Very often in New York, we see anything ranging from these days 90 days good guy notice to 6 months to a year, where he basically says, look, things are not going well. I'm in the middle of this crisis. Things are bad. I want to execute my good guy. Here's my 60, 90 day, 120 day notice, whatever it is. I've paid you and I'm able to walk away clean without any tail chasing me as far as a lawsuit. And many people who are not seeing the light at the end of this tunnel are triggering their good guy clauses right now. And there's nothing stopping you from triggering your good guy clause and getting that clock ticking on surrendering your lease. I hope that was a good answer. Has New York State implemented a moratorium on loan payments, evictions, and/or foreclosures? There is a moratorium on evictions and on foreclosures on residential and on loan payments, but there is no moratorium on loan payments for commercial landlords. There is, however, a moratorium on evictions across the board, and that is through June 20th, 2020 at the moment. We executed our good guy guarantee and paid the 90 days rent as per our lease. Now the landlord says we didn't give also a 90-day notice. How can we give 90-day notice when we were forced to close? Each lease is different and each good guy guarantee is different. But usually the lease prescribes for how the 90-day notice is given, meaning the specific method of delivery of the 90-day notice is prescribed in the lease. So as long as you follow that lease to a T, and what many 90-day good guy notices say is you must deliver this 90-day notice by certified mail, return receipt requested, prior to the beginning of a new month, March 31st, to begin the 90 days. Possibly the 90 days must end at the end of a month. And if you do that, then you have triggered the 90-day. Many landlords will say, hey, I don't accept your surrender. But as long as you followed the provisions and triggered the 90-day notice or the good guy guarantee notice accurately, then you can cut off the tail of potential litigation coming later. Joe, you mentioned something about a yellow injunction. What is that? You know, while the landlord cannot go to court, or parties cannot go to court to enforce their leases or their contracts, the landlord has the option of sending you a notice of termination, which is basically a letter that says your lease is now over. Even though I can't go to court, I'm terminating it. And when the courts open back up, I am going to move on that termination. You will not be able to get back into your space and operate your business. The Yellowstone relief is an injunction, but the Yellowstone court is still open. We can run into an emergency part right now if you've received a notice of termination of your commercial lease, and we can go to a judge today within an hour or two and say, look, the courts are not open, but this landlord has terminated our lease and we need to freeze this. This termination must be frozen until the court can decide. And that's what the Yellowstone option is. What if the tenant partially pays? Is such action considered good faith? And would it be considered by the court in any meaningful way? Pursuant to the lease terms, the partial payment doesn't count for anything, but I think in this particular crisis, eventually when you do get in front of a judge and he hears that the tenant partially paid, any reasonable person is going to factor that into their equation on how they're going to decide. So I believe it is meaningful, and I believe it speaks volumes to make even a partial payment if you can't, especially in a situation like this. What about co-tenancy provisions? When you are asking about co-tenancy provisions, I'm assuming that we're talking about subleasing or possibly leasing out portions of your space for survival. Most leases speak to two things, and one is, you know, whether a tenant has the right to sublease the space or to lease portions of the space, or whether the tenant has the right to assign the lease or sell that space. Each lease is different, and that was negotiated up front between the landlord and the commercial tenant. But basically, if you have the right to sublease, that is an option. And if your space is suitable for it, you can go find another tenant who will offer, you know, partial rent and help. Usually, what that says is that if it's something you have the right to do, it's that a landlord cannot unreasonably deny that request. The landlord does have rights, you know, in that situation. Certain things like, I want to see if this tenant is financially stable, if they're able to pay, if they're in a similar business to you, if they're suitable for the building. And as long as the tenant is not unreasonable or the request is not unreasonable, the landlord must accept that if you have the right to sublease in your agreement. And the same thing for a sale of the business or an assignment. Okay, it's pretty much the same rules. All right, guys, I don't think we have any other questions. I think that was it. I'll see you guys next Friday. Everyone have a great weekend, okay?